void agreements, something which is wrong, or we can say which is not binding by law. So what does void means? It's wrong. Simply you can remember it with the keyword void means wrong. Or you can also put one more thing, that it's not binding by law. According to section 2 subclause G, a void agreement refers to the agreement which is not enforceable by law. Now there are a list of things which are expressly declared void agreements. By minor or a person of unsound mind, made without consideration, in restraint of legal proceeding, by way of wager, restraint of trade, contingency, uncertain even, in restraint of marriage, to do impossible act, consideration of the object is lawful, made under bilateral mistake of fact. So let's look at them one by one. Restraint of marriage, given under section 26 of the Indian Contract Act. Every agreement and restraint of the marriage of any person other than the minor is void. Take a case as such, Rao Rani versus Gulab Rani. A division bench of the Allahabad High Court looked into this particular case, wherein the two parties were the widows of the same man, Ram Adhar. After the death of their common husband, a dispute has arisen at the revenue court regarding the matter as to who would inherit a certain zamindari land holding. However, the particular dispute was amicably settled by two parties by signing a compromise deed, wherein it was stated that both of them would inherit it equally. But if any would remarry, the entire right over the property would shift to the other. Subsequently, Gulab Rani married again, and the property came under the complete control of Rao Rani. However, years later, Gulab Rani filed a suit to regain ownership of the part of that particular property, and amongst other contentions claimed that the compromise deed, Chief Justice Ahmad delivered the judgment stating that all that was provided was that if a widow elected to remarry, she would be deprived of her rights even given to her by the compromise. In other words, no direct prohibition to remarry was imposed by the compromise, and the compromise was arrived at in order to preserve the family properties and to ensure their proper management. So any kind of restraint on the marriage of any particular individual is void. Next we have is agreement and restraint of trade. Means you're putting any kind of prohibition in trade. Given under section 27. Every agreement by which one is restrained from exercising a lawful profession, trade, or any kind of it is to that extent is void. Any kind of agreement, just say lawful profession or trade में कोई prohibition रखता है, so that particular agreement will be considered as void or wrong. So let's take another case for the same, Madhu Chandra versus Raj Komal. In this case, two people, Madhu and Raj, were neighboring shopkeepers. They were rivals. Raj agreed to pay Madhu an amount of money for closing his business located near his shop. Madhu closed his business. Raj refused to pay the agreed amount. The court held that the agreement was void. Now take another example. If there are two schools and the schools are in front of each other, so can A school restrict B school from carrying its business? No. The reason being, agreement restraint of trade has been declared void under section 27 of Indian Contract Act. Now going forward, we have some exceptions under an agreement restraint of trade, which in these exceptions, agreement restraint of trade has been declared valid. So first one is sale of goodwill. The seller of the goodwill of a business can be restrained from carrying on a similar business within a specified local limit, so long as the buyer or any person driving title of the goodwill from him carries on a like business therein, provided restraint is reasonable in point of time and space. Now, with this sale of partnership firm or business, goodwills are also same. Like, first of all, what is goodwill? Goodwill is the reputation that is earned by the business. If by any chance if the business is getting a formal end and the goodwill has been sold, so the restrictions can be imposed that the particular name of this particular business won't be used by the previous partners of that particular business. Because if they will be using the particular name, like take for Reliance. Reliance has a goodwill. Everyone is aware about Reliance. So no one can generally come up and use the name of Reliance. And if Reliance has ended his partnership with some person, so Reliance can impose the prohibition on restraint on trade if the goodwill has been sold. Next is partners agreement. An agreement in restraint of trade among the partners or between any partner and the buyer of firm goodwill is valid if the restraint comes within any of the following cases. Now, for partners agreement, there are few circumstances or cases which is to be firstly satisfied. An agreement among the partners that a partner shall not carry on any business other than that of the firm while he is a partner means जब तक वो उस फर्म का पार्टनर है तब तक वो उस फर्म के अलावा और कोई बिजनेस कैरी ऑन नहीं कर सकता है. Second, an agreement by a partner with his other partners that on retiring from the partnership, he will not carry on any business similar to that of the firm within a specified period or within specified local limits, provided the restrictions imposed are reasonable. अब अगर पार्टनर रिटायर हो जाता है तो रिटायर होने के बाद जिस एरिया में बिजनेस चल रहा है उस एरिया में वो सेम बिजनेस एक पर्टिकुलर ड्यूरेशन के लिए नहीं करेगा. अब उस ड्यूरेशन को भी स्पेसिफिक रखना पड़ता है, 2 साल के लिए नहीं करेगा या 3 साल के लिए नहीं करेगा. Third case is an agreement among the partners upon or in anticipation of the dissolution of the firm that some or all of them will not carry on any business similar to that of the firm within a specified period or within specified local limits provided restrictions imposed are reasonable. Now, पार्टनर्स के बीच में यूजुअली एग्रीमेंट्स हो सकते हैं कि अगर फर्म का डिसोल्यूशन होता है, फर्म खत्म होती है इन फ्यूचर, तो उस फर्म के खत्म होने के बाद जहां फर्म का बिजनेस था उस एरिया में 2 साल के लिए आप सेम बिजनेस कैरी ऑन नहीं कर सकते हैं. इवन जब तक डिसोल्यूशन नहीं होता है पूरा कंप्लीट तब तक भी आप सेम बिजनेस कैरी ऑन नहीं कर सकते हैं. An agreement between any partner and the buyers of the firm's goodwill that such partner will not carry on any business similar to that of the firm within a specified period or specified local limits, provided the restriction imposed are reasonable. So over here, one thing is to be remembered that all the restrictions should be reasonable. They should not be prohibited by law. Next we have is agreement in restraint of legal proceeding given under section 21. Any agreement which restrain legal proceeding is void. There are 3 kinds of agreement which are void. An agreement by which a party is restricted absolutely from taking usual legal proceedings in respect of any rights arising from a contract. means आप पूरी तरीके से पार्टी को legal proceedings लेने से मना कर रहे हैं. Second, an agreement which limits the time within which one may enforce his contract rights without regard to the time allowed by the Limitation Act. Limitation Act को नजरअंदाज करके आप कोई limitations लगा रहे हैं. So these are void. An agreement which provides for forfeiture of any rights arising from a contracted suit is not brought within a specified period without regard to the time allowed by the limitation. So in all, you are supposed to respect the time limit which is allowed by the Limitation Act. Going forward, restrictions on the legal proceeding. The section applies only to the rights arising from a contract. It does not apply to cases of civil or criminal wrongs or torts. This section does not affect the law relating to arbitration. This section does not affect an agreement whereby parties agree not to file an appeal and a higher court, thus where it was agreed that neither party shall appeal against the trial court decision, the agreement was held valid. Dharmodas Mining Company Limited versus Satyanarayan Marine and Fire Insurance Company. Next we have is uncertain agreement under section 29. Agreements the meaning of which is not certain or capable of being certain are void. जिनका मतलब ही clear नहीं है या clear हो नहीं सकता है. So these kind of agreements are void. A agrees to sell B 100 tons of oil. There's nothing whatever to show what kind of oil was intended. The agreement is void for uncertain. अब oil भी बहुत सारे type के आते हैं. कौन सा 100 ton of oil? It's not certain. That's why it is void. A, who is a dealer in coconut oil, agrees to sell to B 100 tons of oil. The nature of A's trade affords an indication of the meaning of the words. And A has entered into a contract for sale of 100 tons of coconut oil. So now this is also done from the nature, nothing else. Next, under this category of void agreements, we have section 30, which talks about wagering agreements. Wager is a game of chance in which the contingency of either gain or loss is wholly dependent on an uncertain event. Agreement by way of wager are void, and no suit shall be brought for recovering anything alleged to be won on any wager or entrusted to any person to abide the result of any game or made under uncertain event on which any wager is made. Like take for example of betting. कि अगर इंडिया जीतेगी तो मैं तेरे को 1000 रुपए दूंगा और अगर इंडिया हार गई तो तू मुझे 1000 रुपए देगा. So these kind of agreement, अगर सपोज चलो इंडिया हार गई और उसने 1000 रुपए नहीं दिए तो क्या कोर्ट जाके इसको इम्प्लीमेंट कराया जा सकता है? No, because it's not allowed by law. They are not implemented by law under section 30. Next we have is insurance contracts. Insurance contracts are valid contracts even they provide for payment of money by the insurer on the happening of a future uncertain event, but they are allowed by law. Such contracts differ from wagering agreements mainly in three respects. Now, wagering agreement and insurance contract are different from each other. They are different under three categories. The holder of an insurance policy must have an insurable interest in the event upon which the insurance money becomes payable. Thus, contracts of insurance are entered into to protect an interest. Contracts of insurance are based on scientific and equitable calculation of risk, whereas wagering agreements are a gamble without any scientific calculation of risk. Contracts of insurance are regarded as beneficial to the public, whereas wagering agreements do not serve any useful purpose. For example, you can take a case for Carlyle versus Carbolic Smoke Company. A and B mutually agree that if it rains today, A will pay B rupees 100. If it does not rain, B will pay A rupees 100. Or where C or D enter into an agreement that on tossing up a coin, if it falls head upwards, C will pay D rupees 50. And if it falls tail upwards, D will pay C rupees 50. These all are wagering agreements. So we are done with this particular session with regard to void agreements. So I have covered all the section with regard to this particular topic. Thank you.